Now let's move to Part 5C2. Part 5C2 as we continue our discussions of exceptions to hearsay when the declarant is unavailable. Now, we've talked about the former testimony exception, and now let's move on to statements under belief of impending death. This exception is also referred to as the dying declaration, but it's the proper name is a statement under belief of impending death because there is no requirement that the person actually die. And so that's why there's some sort of straying away from calling it a dying declaration. The person doesn't have to be dead, but they had to believe that they were dying at the time the statement was made, but they must be otherwise unavailable. So in many instances, they probably actually died, and that's the reason that they are unavailable. But a person could have possibly made a statement believing he was dying, but before the trial in which they want to offer his statement, he might have died from something totally unrelated. So the statement is referred to as a statement under belief of impending death, although I will refer to it through this presentation and later on as the dying declaration exception. So this is a statement made by a declarant while believing his death was imminent concerning the cause or circumstances of what he believed to be his impending death. And so this is pretty obvious as to why this exception is deemed to be somewhat trustworthy. You have a person who believes that they're dying. They probably have nothing to lose. They probably feel that they're going to meet their maker, and so they wouldn't want to die with this, lie on their lips. So we believe that these types of statements have some degree of trustworthiness. And of course, the person is currently unavailable, so we allow exceptions to come in, these statements to come in under this exception. Now, the requirements, of course, is that one, the declarant is unavailable. He believes his death is imminent, whether or not he actually dies, although he must be otherwise unavailable. And the statement concerns the cause or circumstances of what he believed to be his impending death. Now, there are a number of factors you would look at to help determine whether or not he really believed his death was imminent. You want to look at the words. The person might have said, I won't be around, always remember me. So you're looking at the words that they're saying, the nature of the wounds. If there's blood everywhere, he's been shot in the chest, he probably does believe he's dying. Whether others are present, the time between the wound and the injury, the opinion of a physician, or any other factors that suggest that the declarant has abandoned all hope or expectation of recovery. So if you have the declarant, on the other hand, saying, when this is over, I want to do some things differently, moving forward. Or, I need to see what I'm going to do about my business now that I'm probably going to be limited in some way. Those statements would suggest that he did not believe that his death was imminent and at that particular time. Now, we also have to look at the content of the statement. The statements that apply under this exception are only those that relate to the cause and circumstances surrounding what he believed to be his impending death. The cause and circumstances generally will relate to the person, mode, or mechanism. John shot me. The person, the mode, and the mechanism. So that's generally what we're talking about. It has to deal with the cause and circumstances. So if the person believes they're dying and they start talking about other things, which child they love the best, or what the will should say, all of their regrets in life, all of those types of statements will not come in under this dying declaration exception. This exception only brings in statements regarding or related to the cause and circumstances of what he believed to be his impending death. So the words can be, hand signals, writing. There are cases where people have written out the words. They've nodded in response to questions. They must have firsthand knowledge about whatever he's speaking. They must have firsthand knowledge. This doesn't apply to conjecture. I think, Bob must have poisoned me. I'll bet those people conspired to make this happen. Those statements of conjecture, speculation do not apply. These are statements statements of which they would have firsthand knowledge that fall under this particular exception. Now, suicide notes do not, are generally not included in this exception because, for one, and most importantly, the death is not imminent since at the time of the statement the mortal wound has not been inflicted. So, writing the note removes the spontaneity and the consequent reliability and trustworthiness of a statement made after the mortal wound has been unexpectedly inflicted. So there with the suicide notes, there's time for reflection, there's time for fabrication, and we don't know exactly when it was written, how long it took them to write it. But when a person has an unexpected mortal wound that spontaneously occurs, that's where the reliability comes in, and you don't have that when you're dealing with suicide notes, so they're generally not included. So shortly after being shot in the chest by his pregnant wife, Dan managed to crawl through a pool of blood, clutching his chest to his cell phone, and called 911. As the EMT loaded Dan up into the ambulance, he tells his wife, "Baby, once the baby is born, we can't handle our problems like this anymore." Dan dies. Does the statement conform to the dying declaration exception? Well, no, it does not, because Dan did not believe his death was imminent. By him saying, "Once the baby is born, we can't handle our problems like this," that shows that he expects to be around. The person has to believe their death is imminent at the time they make the statement in order for it to fall under this exception. Marjorie was misdiagnosed as a result of her doctor failing to see a tumor on her lungs. She files a lawsuit against the doctor. Before she dies, her attorney arranges for her to take a deposition so that her testimony will be preserved. Marjorie dies before the trial. Can her deposition testimony be used at trial as a dying declaration? No, even though she believed that she was going to be dying soon, this exception applies to those situations where, the person believes that they are effectively in the process of dying at that moment when the mortal wound has been unexpectedly inflicted. That's where your trustworthiness comes from. That's where your reliability comes from. It does not come from a situation where you have a person who's had weeks or months or years to plan what they're going to say. They've had time to reflect and possibly fabricate. So a person who is terminally ill from a disease such as cancer, who goes and takes a deposition or writes a letter, that does not conform with the dying declaration exception requirement, so that would not be admissible here. Now let's talk a little bit about the statement against interest exception to hearsay. And of course, this is another exception that applies when the declarant is unavailable. And this includes a statement which was, at the time of its making, so far contrary to the declarant's pecuniary or proprietary interests, or so far tended to subject him to civil or criminal liability, or to render invalid a claim by him against another, that a reasonable man in his position would not have made the statement unless he believed it to be true. A statement tending to expose the declarant to criminal liability and offer to exculpate the accused is not admissible unless corroborating circumstances clearly indicate the trustworthiness of the statement. So this is pretty straightforward in terms of a statement against interest. If a person makes a statement against his own pecuniary or proprietary interest, or might subject him to criminal or civil liability, or render a claim that he has invalid, we assume that a person would not make the statement unless it were true. And so if a person is saying, "Yes, I committed the crime," if a person says, "I'm the one caused the accident, I was drinking and driving," those are statements against their interests, and they're reliable because we assume that a person would not make such a statement unless the statement were true. And so that's where we get this particular exception. So it applies to a number of different types of interests: pecuniary interests, proprietary interests, dealing with whether it's money, property, subject him to civil or criminal liability, or render a claim by him invalid. He has that he might have against someone else. A reasonable person that would probably not have made the statement unless the statement were true falls under this exception. So pecuniary interest, you may have, no, I didn't drop that $10 bill, or I think my trade in is worth less than book value, so those are statements against their pecuniary interest. A person may say something about their property, or our home is community property, or that may subject him to civil liability. I was texting when I was driving, or I may have had a few too many drinks tonight. A statement could subject him to criminal liability. I killed the guy, or render a claim that the declarant has against another person invalid. My boss did not sexually harass me. All of these types of statements are statements against interest and may be admissible, provided the declarant is unavailable at the time. So we have two basic requirements here: the unavailable declarant, and the statement is against the declarant's interest when made. And in some instances, there's a third requirement. If the declarant makes an incriminating statement that inculpates himself and exculpates a third party, there must be corroborating circumstances that indicate the statement is trustworthy. So we have, that first requirement, that, pecuniary interest, proprietary interest that subject him to civil or criminal liability, or render a claim invalid that he has against someone else. All of these types of statements, any of these types of statements, can be a statement against interest that falls under this exception that may be offered into evidence. Now, there are three important variations on the rule. And you need to keep in mind. So, in some instances, you may have a person who makes a statement that is self serving in some respect and also disserving in some respect. I did it, but I was forced to do it. Okay, so you have the person saying, I did it, but I was forced. And in that situation, you have to think about which one predominated in order to determine, is this really a statement against interest? If you have a person saying, well, I didn't mean to do it, I didn't try to do it, I didn't intend to do it, I hit her, but I wasn't trying to, so they're absolving themselves of liability by making that part of the statement. So is that really a statement against interest? So you have to look at which part predominated. Now, in some instances, you have a person implicating themselves and someone else as well. This is referred to as an interlocking statement. He may say, I did it, but he helped me do it. So not only is he implicating himself, but he is also implicating someone else. That's referred to as an interlocking statement. And we'll talk about it a little more in a moment. But a person may also implicate himself and completely exculpate someone else. So if he says, well, I did it and he didn't do anything, then you have, in that situation, you must corroborate. There must be corroborating circumstances in order for that statement to be deemed trustworthy and admissible, because you have that in a lot of situations. Say, for instance, if a person may be serving a life sentence or they're dying and have nothing to lose, then in those situations, they'll just take all the blame. So in this first situation, we talked about, when a statement contains both an inculpatory disserving aspect and an exculpatory aspect, the court must determine which aspect predominates. Against interest only if the disserving aspect predominates. So if you have a person that says, well, I didn't intend to do it, and that's what the whole claim is about, whether or not they had intent, then it's probably more self-serving than it is disserving, and it's not going to be deemed to be against interest, and it would not be admissible under this exception. Now, if he inculpates himself and a third party in an interlocking statement, then only the part implicating the declarant is trustworthy and reliable. So if you have a defendant, if he's made this extensive statement that also implicates someone else, then only the part that where he implicates himself can be admissible against him. Now, if you have co-defendants and one of the defendants, if he confesses and he implicates his co-defendant, then of course in that situation the U.S. Supreme Court has said that we have to sever those trials and try them separately, because clearly we can't have the two defendants being tried together and offering this statement against one of them when it's pretty clear you've excised certain parts of it out that is also implicating the other guy, and that he's deprived of his Sixth Amendment confrontation because he cannot cross-examine the person who's effectively testifying against him, which is his co-defendant, because his co-defendant does not have to take the stand because he has this absolute privilege against self-incrimination. So it will prevent him from being able to cross-examine, and it also would have the jury hear this incriminating statement against him made by his co-defendant. So the only reliable part is the part where a declarant implicates himself, and the other part is excluded completely. Now, in some situations, you will have a person make an incriminating statement where he completely exculpates a third party. When he says, "You know what, my father didn't do anything. I'm the one. I forged all the records. I'm the one who did the tax returns. I made all the errors. I made all the mistakes. He didn't do anything." Well, in that situation, we have to have some corroborating circumstances of trustworthiness. We have to look at whether he had a motive to misrepresent, whether the statement was made spontaneously, the time of the declaration, the relationship between the parties. Is this father and son, husband and wife? The relationship between the witness and the accused, the general character of the witness, whether other people heard the out of court statement, or whether it was made voluntarily after Miranda, or whether it was made to curry favor with authorities, and all these types of very relevant factors to try to determine whether this person really did the things that he's claiming, or if he has some other motive to misrepresent the information. So if he's saying, "I'm the one who really committed the crime," we need some facts and surrounding circumstances to suggest that he is telling the truth and he actually is the person to commit the crime. Now, this exception applies in both civil and criminal cases. First-hand knowledge of the information of which the declarant spoke. He must have first-hand knowledge. It must be against his interest when made, and the declarant must know that the statement is against his interest when he makes the statement. If he makes a statement and then he later finds out, "Oh my God, that's a crime," then of course it doesn't have the trustworthiness, because he has to know that he's potentially subjecting himself to criminal liability. It may be made to anyone at any time. It need not be made to law enforcement. So it's any statement against interest, and this is a statement. It's not necessarily, a lot of confessions are statements against interest that the prosecution offers. There, that statement falls into another category we'll discuss later on, called admissions. But most of those statements are statements against interest. But keep in mind that a statement against interest, it doesn't have to be a statement that's being offered against an accused or a person in trial. That person need not even be a party to the case. It may be a civil case. And this particular person, the declarant, is obviously unavailable. So he could be someone who's just gone off to another country and said that he did something, and the prosecution or the defense or the plaintiff or whoever wants to offer his statement. So he does not have to be, it's not a statement offered against a person, but it's just a statement that a person made against their own interests. And one of the parties in the case, whether it's the plaintiff or defense or prosecution, wants to offer that statement into evidence. And if those requirements are met and it doesn't violate any other rules, such as the Confrontation Clause, then the statement can be admissible. Okay, and so with that being said, a lot of these statements potentially will violate the Confrontation Clause, as we said before, because many of them are testimonial in nature or have the effect of testimony. And whenever you have a statement that has the effect of being testimony that's offered against an accused, and, as with all these exceptions, he is unavailable for cross-examination. He's unavailable, period, but including for cross-examination, then it could potentially violate the defendant's confrontation rights under the Sixth Amendment. So we'll talk about that in the last section a little bit more. But for now, keep in mind, as we said before, that whenever you're dealing with statements under this exception where the declarant is unavailable, you're going to also have that additional and separate objection that the statement, admitting the statement or offering the statement against an accused, violates his rights under the Sixth Amendment Confrontation Clause. So let's take a couple of examples here. Kelly and Francine were driving to Kansas for spring break. After about 15 hours on the highway, Kelly became drowsy, fell asleep behind the wheel, and veered into the oncoming lane of traffic, striking Peter's car. When the police arrive, Francine tells them that Kelly fell asleep behind the wheel because she had been driving a long time and had taken some prescription medication that she knew made her drowsy. At the time of the trial against Kelly, Francine cannot be located. Can the prosecution use her statement against Kelly in the trial? Well, this certainly does not come in under the statement against interest exception, because this is Francine making the statement. And when Francine talks about Kelly falling asleep behind the wheel and taking drugs, that does not subject her to any civil liability. It only subjects Kelly to civil liability or criminal liability. Even if Francine had said, we're both drunk, we've both been drinking, we've both had drugs, it still would not be against Francine's interest because Francine was not driving the car. So there's no potential criminal liability for being intoxicated. There's no civil liability for causing the accident because she was not driving. So this does not come in under the statement against interest exception against anyone. It cannot be offered under this exception at all. And since they're obviously, it is hearsay because they want to use it to prove that Kelly was in fact had been driving for 15 hours and that she had taken medication. So it is a hearsay statement, but it does not conform to this exception because Francine is not against Francine's interest when she made the statement. Omarion and Kendall were arrested for aggravated kidnapping a 12-year-old girl who they sexually assaulted several times while she was in their custody. Omarion stated that Kendall came to pick him up and told him that he wanted to abduct a girl. He says he rode with Kendall past a middle school and watched Kendall offer the victim a ride home. He says Kendall drove him and the victim to an old house in the country where they repeatedly raped her for 3 days before she escaped. Omarion stated that he never felt very comfortable about the situation and wanted to let her go long before she escaped. Kendall did not make a statement at all. In Kendall's trial, Omarion refused to testify, asserting his Fifth Amendment privilege against self-incrimination. So the prosecution would like to offer Omarion's statement against Kendall. Can any portion of Omarion's statement be offered against Kendall in his trial? Well, aside from the fact that this case has a lot of obviously Sixth Amendment issues, since he's going to refuse to testify, he can certainly refuse to testify because he has a privilege against self-incrimination, so he is unavailable to the prosecution. Now, in this case, he made some incriminating statements, but he also did a couple of things. One is it's interlocking because he's also implicated someone else, and he's even put more blame on the other person, saying that it was the other person's idea. He drove, and that this went on for 3 days. So he was really trying to shift the blame a lot. But the portion of his statement that even where he says the things that he did are against his interests. Only the parts of the statement where he implicates himself are reliable under this particular provision. So he would not be able to offer the parts of the statement where he implicates Kendall at all under the statement against interest exception, because the statement against interest only goes to the statements that you make against your own interest. So everything that he says about Kendall would really need to be excised out or deleted from the tape recording. Now, if it is not possible to do that in such a way that it is very obvious that he's talking about this the defendant there, then clearly that statement would not be admissible at all. And being that we're going to be talking about the Sixth Amendment rights very soon, this statement certainly would violate the Confrontation Clause as well. Shane was serving 2 consecutive life sentences for killing his entire family. Shortly after he was arrested, his brother was also arrested for raping a young girl in their neighborhood. Shane wrote a letter to the prosecutor handling his brother's case and told her that he was the one who'd raped the little girl and that his brother had nothing to do with it. At brother's trial, he sought to admit the letter that Shane had written to the prosecutor to prove that it was his brother and not him who had committed the rape. Shane was was unavailable. The prosecution objected that the letter was hearsay. How should the court rule? Now, as we said before, when a person is taking all the blame and completely, escapade someone else, then we know that there must be some surrounding circumstance. We look at all the surrounding circumstances to determine if the statement is trustworthy. So here we already know that Shane is serving two consecutive life sentences. So he's not going home anyway. So he would want his brother, he would take the blame for his brother's crime in order for his brother to not have to serve the sentences. He's going to be there anyway. So because we can clearly see that he has a motive to lie in a situation like this, there must be corroborating circumstances to tie Shane to that crime, to show that he really committed the crime. So we would certainly want to know. I mean, he's in jail anyway, so that's probably going to be pretty difficult for him to do if he was in jail at the time. But if he was out, we would certainly look to see, did he have fingerprints there? Did he know the female? Did someone see him in the neighborhood? All of these corroborating circumstances would help us to determine whether or not Shane's statement was actually trustworthy, and if we can actually whether it was sufficiently against his interests for us to allow it under this exception.